Well, it looks like we've had some new documents dropped today in the Idaho 4 case, so let's go ahead and start going over them. Hey guys, this is Jules with True Crime Reactions. We had a couple of documents drop today, and I have not been able to read over the last one that posted, so me reading it to you and going over it right now is going to be the first time I have actually read it. So just to kind of go over some of the things that have been going on over the past few days. Now, I do post all of the documents that drop on my community tab, but I did not place this one because it was kind of long, so I knew I was going to talk about it. But earlier today, I did attach 2 different motions to a post. It looks as if the state has filed a motion hearing for the defendant's motion requesting release of grand jury materials under the qualified protective order. And we know that a few weeks ago there was a grand jury, and then the following Monday there was the arraignment court date where the standing silent situation happened. And a few hours after that, we received information that the defense had not yet received anything from the grand jury, and they were requesting the transcripts. Well, there was a response from the state at that point stating that the transcripts were in process, that everything getting gathered for it to be sent over to the defense was in process. But it seems that with this motion that has been filed for June 27th, that the defense must not have gotten like anything, I'm guessing, because they filed 2 motion hearings for this. And the second one, I am really kind of confused on the difference in the verbiage on these, honestly, because the second one is motion hearing, defendant's motion to make available record of all proceedings of the grand jury. And the other one is motion requesting release of grand jury materials under qualified protective order. So I don't know the difference between these two. I'm going to try to do some more research on that so I can let you guys know. But it looks like it's the exact same thing, and they're on the same date at the exact same time. But verbiage matters, the way that words are used matters, so I'm going to try to figure out that one. But when it comes to the defense posting those today, there was a state's supplemental response to the defendant's motions, the 2 we just went over, that was also posted. Okay, comes now the state of Idaho by and through the Latell County prosecuting attorney and respectfully supplements its May 30th, 2023 state's response to defendant's motions regarding grand jury record and transcript. As the state indicated in its initial response, a proposed stipulation for the order for preparation and release of transcript and record of grand jury proceedings with conditions was being reviewed by defendant's counsel. Unfortunately, the state and the defense have not been able to reach agreement. So it seems like there's an argument between the state and the defense when it comes to the preparation and release of the transcripts and record of the grand jury with conditions. But all those conditions should be is that certain names and certain things get redacted. But are they trying to legitimately hide information, and maybe the defense is telling them, hey, you know, what you want to do with this isn't going to tell us what we want to know? Because that's a big possibility, I guess. Consequently, the state submits the following for the court's consideration. Access to the audio record and a transcript of grand jury proceedings is controlled by ICR 6.2c. The overriding secrecy and confidentiality of grand jury proceedings is described in ICR 6.3. Reading these rules together, the only exceptions to the secrecy and confidentiality of grand jury proceedings are for counsel to listen to the record of the proceedings of the grand jury or to obtain a transcript of the proceedings, the list of juror votes which may be disclosed to counsel by order of the court under ICR 6.5d, and disclosure of what was said and done in the proceedings by order of the court for good cause shown under ICR 6.3c. So if it's stating that the only exceptions to the secrecy is if counsel listens to the record or gets the transcript, if the counsel then gets a list of the jurors, or for the counsel to know what was done or said in the proceeding. But that seems to be just exactly, plain and simply, what the defense is asking for. So I don't... Okay, let's continue. The defendant's motion to make available the record of all proceedings of the grand jury pursuant to ICR 6.2 appears to go beyond what is permitted by the applicable court rules. How? Additionally, the defense proposes that the court unseal various grand jury proceedings and then make them subject to a subsequent qualified protective order. See, that's what I was wondering about. If they were trying to unseal it for the public, or if they were just trying to get them themselves, the defense just get them themselves. That's one thing I've been kind of confused on, which is why I've had issues with the media petitioners and the Gonsalves family gag order and then all these things going on, because it's just super confusing. Is the defense trying to get the information themselves, or are they trying to get the information about the grand jury themselves plus actually have it released to the public the way we get this document we're reading right now? I'm just a little confused. This is contrary to the requirement that the grand jury records and transcript remain sealed under ICR 6.2, 6.3, 6.5, and ICAR 32G7 and I4. Geez, that's a lot of freaking rules. None of these records can be or should be unsealed. None of these records can be. Oh, there's always exceptions, sweetie. Rather, the court should allow the parties to listen to the record of the proceedings of the grand jury and to obtain a transcript of the proceedings and the list of jury votes under ICR 6.5. Note, ICR 6.5D specifically requires that the list must remain sealed, but may be disclosed to the prosecuting attorney, the defendant, and the defendant's counsel by order of the court. Emphasis added. Ooh, they smartasses, bro. As mentioned above, disclosures of the grand jury of what was said or done in grand jury proceedings beyond the audio recording, transcript, and list of jurors can only be done by order of the court for good cause shown. The state respectfully submits that the defense has not made such showing for the detailed list of items they requested in their motion to make available the record of all proceedings of the grand jury. The Idaho Supreme Court has explained that grand jury proceedings are intended to the extent possible to be secret. A defendant who seeks more than what the rules expressly allow must show good cause for access to grand jury records. For example, in State v. Abdullah, a defendant convicted of first-degree murder and sentenced to death argued to the Idaho Supreme Court that he was entitled to grand jury selection transcripts to determine whether he had any basis to challenge the grand jury term. The court explained that the defendant must demonstrate good cause for this court to allow his review of the grand jury selection transcripts. Because the defendant provided no legal basis for this court to allow his review of the grand jury selection transcripts, the court declined to order the district court to provide defendant with the requested grand jury selection transcripts. See, I have a problem with that. I really do have a problem with that, because they are literally trying to put this man, like I've mentioned, in front of a firing squad, okay? And in order for him to be able to validate that the evidence being presented against him in a grand jury is actual, factual, and valid, he should have the right to listen to the transcripts, to see the jury list, to be able to see exactly what was done, what was said, what was presented, who was a witness. He should be able to go through every little minute microscopic microsecond with the tiniest fine-tooth comb if he so wishes. And I don't quite comprehend why this is such a big deal. I think that they really just want to fight with each other and try to get as much money out of these cases for all these stupid billable hours that they possibly can, because honestly, this is just a stupid fight. This is all this is a stupid fight. The state respectfully submits that the appropriate course of action at this point is for the court to enter an order for preparation and release of a transcript of the grand jury proceedings, except the deliberations. and permit the state and defense to obtain copies of said transcript and the audio recording of the grand jury. This is with the understanding that the same will remain confidential as outlined in the state's proposed order for preparation and release of transcript and record of grand jury proceedings with conditions, appended to the state's May 25th, 2023 state's response to defendant's motions regarding grand jury record and transcript. The state also stipulates to the list of jurors' notes being disclosed to counsel pursuant to ICR 6.5. Once the transcript and audio recording have been reviewed by the parties, the court, on motion of a party, can proceed to consider whether there is good cause required by ICR for further disclosure. So what I'm understanding from this is that they're okay with them listening in on the audio, going over the transcripts, and even having the jury list, I guess. But all of the additional stuff, i.e. the genealogy information that the defense has been asking for, that the state is adamant about making it admissible in court by filing the motion of limine, they're stating that that information is outside of the scope of all of these rules. That's what I'm getting from this. And I still just find it preposterous that this is still happening. Even with a new judge, I don't understand why the state is able to just sit back and hold on to so many things. Like, I'm totally okay with the public not knowing stuff, but whenever you are getting documents like these get released and you see the games that are being played, and it's not just one-sided, okay? It's both sides, okay? They're passing that ball quite a bit between each other. But this just seems like a thingy measuring contest. I mean, that's what I see in my head whenever I'm like looking at the way this is just going back and forth with all of this stupidity. But then it also makes you wonder, like, why is the state fighting this so hard? If they are so sure that their genealogical testing was done legally and by protocol, and that the results are correct to what they're claiming that they are, and there shouldn't be any issues with it, then what are they hiding it for? Why keep throwing, like I mentioned, all these billable hours at the state into this case instead of just handing over the information? Just give it to them. What are you hiding?